This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we explain why it is not wise to explain a scheme to defraud to two FBI informants, and why an insurance fraudster tried multiple bases for appeal and still goes to jail. Brian Higgins diverted for personal use funds he received from his mortgage servicer to repair damage to his home caused by a broken fish tank. He also filed a lawsuit against two witnesses for the prosecution, accusing them of misdirecting the funds instead of himself. For his conduct, a jury convicted Higgins on 3 counts of mail fraud and 2 counts of retaliating against a witness, victim, or an informant. In the U.S.A. versus Brian Higgins, the Sixth Circuit on October 6, 2023, affirmed his conviction but gave him a small win by requiring the district court to reconsider the amount of restitution he must pay. In 2007, Higgins bought a house in Dayton, Ohio, which he financed with a $900,000 mortgage. By April of 2010, Higgins had defaulted on his mortgage payments and, as of October 2016, still owed almost all that he had borrowed. On top of that, the house was encumbered with another $815,000 in liens, including for federal taxes over the years. Higgins' 1,000-gallon fish tank sprang a leak and caused significant damage to the house. Higgins commissioned Michael Marshall and Scott Waters, contractors and owners of United Demolition, to do the work. But during their initial consultation, Higgins detailed his plan to divert the home repair funds for his own personal use. Higgins asked that the contractors help him with his plan by falsifying documents to procure the insurance monies. Unbeknownst to Higgins, however, the contractors were confidential informants for the FBI on an unrelated matter. Higgins was initially indicted for mail fraud and wire fraud because the contractors told the FBI about his scheme. But after learning of the contractors' roles in the government's investigation, Higgins, while under arrest, filed a pro se lawsuit against them both, highlighting their role as informants and alleging that they were the ones who defrauded Nation Star and the insurance company. The jury found Higgins guilty of 3 counts of mail fraud and 2 counts of retaliating against the government witness, and ordered him to pay $84,113.04 in restitution. The Sixth Circuit noted that the trial court did not abuse its discretion when it denied Higgins' motion for additional funds to hire an expert accountant, and argued the district court erred when it admitted evidence of the $815,000 in liens that were on his residence when he filed his insurance claim, and many other spurious grounds for appeal. Higgins placed both of his general and specific intent at issue when he pleaded not guilty to the mail fraud charges. Evidence of a defendant's financial condition is relevant and admissible for the proper purpose of establishing motive or intent in cases involving financial crimes. Higgins' significant financial woes revealed an incentive for him to use insurance monies for his own purposes rather than their intended purpose. Trial testimony bore this out. The contractors explained how Higgins misappropriated the insurance funds for personal business ventures. The government moved to introduce the recordings to prove retaliatory intent and common plan in relation to the witness charges, which the court allowed. The parallel between Higgins' earlier advice to another person to flip and reverse allegations of wrongdoing against an accuser of that person and his later actions in accusing witnesses in his own case of the very crimes for which he stood trial was striking. The Sixth Circuit explained that any reasonable juror would understand that his statements were not confessions to any of the crimes charged. Rather, they would grasp that this evidence might shed light on Higgins' possible intent in filing suit against the contractors. Higgins' final challenge was to the district court's order of restitution. The recommended amount equaled the total funds Higgins diverted from the insurance disbursements. The Mandatory Victims Restitution Act requires the district court to award restitution to victims of fraud. Restitution must be awarded in the full amount of each victim's losses. That said, restitution is intended to compensate victims only for losses caused by the conduct underlying the offense of conviction, and therefore the Sixth Circuit affirmed Higgins' convictions and ordered the trial court to inquire further as to the appropriate amount of restitution due to Nation Star. This victory might be Pyrrhic in that the Sixth Circuit and the trial court might just decide that the restitution amount should be even more than originally ordered. In my opinion, people who commit insurance fraud and are caught have chutzpah without limitation. This appeal, with dozens of pages of opinion to resolve the multiple complaints about his conviction that Higgins filed, the Sixth Circuit did away with all of his arguments and threw him a bone by requiring the circuit court to reconsider the amount of restitution, even though it will probably never be collected, considering the debts and liens that may have caused him to try to resolve his problems with insurance fraud. This video was adapted from my blog Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. Please tell your friends and colleagues about this blog and the videos and let them also subscribe. You can also subscribe to the videos on YouTube or rumble.com. And if you do, I'd appreciate it as you watch the videos if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you wish further detail on insurance, insurance law, insurance claims, and insurance fraud, please consider subscribing for a very small fee to my Substack publications and my locals community. Thank you for your attention.